I want to get straight to our guest. He is the president of Judicial Watch. Tom Fitton joins us right now as we have some news regarding the email situation surrounding Hillary Clinton and the Benghazi attacks. Tom, it is a pleasure to have you on the show with us today.
Thanks for having me, Annie.
Absolutely. So I want to get straight to the point regarding the latest endeavor that Judicial Watch has been able, the latest victory you've had in getting more information surrounding the Benghazi attack, Hillary's emails. As Judicial Watch pushes forward on this particular issue, tell me what is in the public interest of what you were trying to uncover, what you think the public needs to know, or what you're trying to specifically get to the bottom of.
Well, we have a right to the documents under the law. We had asked for documents about the Benghazi talking points, and in doing so back, it's now 4 or 5 years ago, 2014, I think, is when we began asking questions. We forced them to admit they had all of these Clinton emails they weren't telling anyone about. And we still don't know where all the emails are. The judge in our case is concerned that Mrs. Clinton was using the email system to evade FOIA, and he wants to know where all the emails are, and he wants to know why the Justice Department and State Department may have been trying to shut the case down before telling us about the emails. So he granted us the ability to ask questions of several witnesses, and now, just yesterday, he ruled that Hillary Clinton has to come in for questioning within 75 days.
This seems like a pretty significant victory on the part of Judicial Watch. You are a nonpartisan group that works to expose those things that we do have the right to see as public. Do you have speculation on the purpose of Hillary's method of email use, of the choice to use a Gmail account? Is there speculation surrounding that was intentional, or is that just what you're trying to discover?
Well, the testimony seems to suggest from others that she didn't want anyone to see her emails. So it's pretty clear, She didn't want. One of her top aides said she wanted to keep her stuff private. And people in the State Department made it clear that they didn't want her email address getting out there. You mentioned Gmail. She wasn't necessarily using a Gmail account, I don't think. Well, maybe she was, but either way, one of her vendors allegedly sent all of her emails to a Gmail account, which is why the judge also authorized us to issue a subpoena to Google to see what we could find.
We're on the phone with Tom Fitton from Judicial Watch. Tom, this is Ryan. When I first saw this story break, my first thought was, well, it's Hillary Clinton, so she's going to file something and either delay it or we'll never hear it one way or another. Is that a possibility that we just won't ever hear from Hillary?
Anything's possible. It's unlikely, though. I think this is going to proceed, and we're going to depose her in person under oath as the court ordered. It's difficult to overcome a court ruling that your testimony is needed for the court to figure out what to do about a controversy like this. So, there's always a possibility for appeal. You never know. But it's just a matter of what date we're able to come up with. We just have to match dates and come up with a time for a deposition.
And her argument I saw is that she's already been pretty forthright about this, but that the other side is saying, well, no, you haven't. What more is there? What has she not said that we're hoping to hear this time?
Well, she really hasn't been questioned about the use of her system. Why did she use it? What was she told about the legalities of it? We get to ask her about records related to the Benghazi attack because this is a case about getting documents about that. And she hasn't been asked directly about that. There have been written questions she answered under oath, but the court said her answers were incomplete, unhelpful, or cursory at best. So the judge wants to know, how did she arrive? This is a quote from the judge. How did she arrive at her belief that her private emails would be preserved by normal State Department processes for email retention? Who told her that, if anyone, and when? Did she realize the State Department was giving a no records response to FOIA requests for her emails? It showed that she suspect that she had any obligation to disclose the existence of her server to those at State handling the FOIA request. These are sorts of, pretty basic questions.
Mm-hmm. Yeah, we're speaking with the president of Judicial Watch, Tom Fitton. Judicial Watch's efforts were originally the source of exposing this email issue that surrounded Hillary Clinton. And this specific lawsuit seeks records concerning talking points or updates on the Benghazi attack. We've heard her say in when she was facing in that hearing, at this point, what difference does it make? It seems as though to some people there still is a significant amount of information that Hillary's testimony could potentially lend to the question surrounding the talking points part about the Benghazi attack. Do we know anything specifically with what we have so far about what kind of talking points were discussed in these emails, or is that what we are seeking?
Yeah, I mean, we have some information Judicial Watch received in a separate case, which is why we asked again what Hillary Clinton had, that the talking points were written initially by the White House. And they weren't intelligence documents, as was suggested. The White House came up with a political spin on the attack. And so there are emails about Benghazi, for instance, that we just got last week. That's why the court's annoyed. They're still finding Clinton emails. Wants to know what's going on.
Tom, it's not that if you just made this request recently and you just got these documents. This has been quite the ongoing process, and probably much to Hillary's chagrin, Judicial Watch is pretty persistent on these issues, and you continue to dedicate yourselves to finding out this information. How long and how arduous is the process for discovery to make sure that you can get the information, the documents, that I think a lot of people would have, thrown their hands up and said at this point, what difference does it make? What kind of effort does it take on Judicial Watch's part to try to uncover this information for the American people?
Well, we've been in a federal court in many cases on this issue. We had discovery in another case. We had several court hearings in this case. We were in court in December on this very issue, whether we should be able to depose Hillary Clinton. And on the other side were 6 lawyers for the government, from the State Department and Justice Department, and 2 lawyers for Hillary Clinton, 2 lawyers for her top aides. It was 10 lawyers versus us. And outrageously, this Justice Department and this State Department continue to try to defend her conduct and prevent us from getting any further questions answered. President Trump, when he tweeted about this, he said it was disgraceful. And I think he should just tell the Justice Department to stand down. Why are they protecting Hillary?
Yeah, that is a good question. I'm glad you brought up President Trump. According to this article I have right now, the court ruled that the Clinton email system was, quote, one of the gravest modern offenses to government transparency. I look at what we've seen happen to President Trump in these 3.5 years that he has been leading this country, and the work that Judicial Watch is putting in to uncover this. It does feel a little bit like there is a different justice system for one party versus the other. If you weren't there pushing on this, would this just completely go away? Is there no other interest in uncovering what this gravest modern offense to government transparency, according to this court system, that Hillary Clinton is responsible for?
Yeah, it's pretty clear the Justice Department doesn't want to look at this issue again, and it's up to Judicial Watch to do it. Congress is out of completely AWOL on this, but for Judicial Watch, we wouldn't know about any of this from the beginning through now. And this is another way of getting accountability, having Mrs. Clinton ask questions, under this court process about what she was doing and why. So it's a great victory for accountability. It's not exactly what everyone wants in the end, but of course, you get what you can get and you do what you can do. And this is more than Mrs. Clinton wanted to go through in terms of having to answer questions here. So we overcame her objections and the objections of the Justice Department and State Department. So it's, as the court said, these are extraordinary circumstances that require her testimony.
Last question for you, Tom Fitton, Judicial Watch president. I believe I read 75 days to get this done. Are we going to have something in that amount of timeline? Does it take longer than that? Could it be sooner? What's the expectation?
We'll see how quickly Mrs. Clinton is available for a deposition, but we want to move relatively quickly, so we'll see. I don't know. 75 days is what the court order is, so I suspect it will happen before then.
Well, I encourage people to follow Judicial Watch on Twitter. Go to judicialwatch.org. Hard work being done by your organization there, and we are very grateful for your time today.
You're welcome. Thank you, guys.
Absolutely.
Thank you, guys.